The First Amendment on trial. We're in the D.C. Circuit Court of Appeals, the case Democracy Partners versus James O'Keefe and Project Veritas.
So what's the First Amendment problem?
First Amendment problem is this should not have gone to a jury at all.
Good. I'm going to record everything I hear here and I'll share it as I please. And then I can get away with it because I'll say it's First Amendment protected. Oh, come on.
And that's what investigative journalists do. This determination by this court decides whether undercover reporting can exist in the nation's capital moving forward.
Whether this Ms. Maas was a fiduciary or not, if she was, then that's the end of muckraking.
Here are the issues before the Federal Appeals Court in Washington, D.C. Issue 1, is it fraudulent misrepresentation for an undercover reporter to misrepresent themselves and do undercover journalism in the District of Columbia? Does the alleged harm or damage come out of the infiltration or investigation itself or the publication of the video? Now, we're arguing here that the harm is coming out of the publication, therefore it's covered by the First Amendment. Sometimes journalism leads to people getting fired. Sometimes journalism leads to people losing their contracts because of the words that came out of their mouth. They're arguing the harm was due to the act of going undercover, which is, we think, is false. Issue 2, is there a fiduciary duty? Do I owe a fiduciary duty to the Hillary Clinton Democracy Partners people simply because I was undercover inside of them? More specifically, can our undercover intern, who is a part-time, unpaid, and who did not sign an NDA, can she have a fiduciary duty hoisted on them unilaterally? Now, we had litigated to a jury in D.C. in September of 2022. We won on 3 counts and lost on 2. This was a story involving a group called Democracy Partners, and Bob Creamer admitting they were paying people to bird dog at Trump events in 2016.
She was one of your activists
who had been trained up to bird dogs.
Yes.
So the term bird dogging, you put people in the line at the front, which means they have to get there at 6 o'clock in the morning, so they're getting the front of the rally, so that when Trump comes down the rope line, they're the ones asking him the question in front of the reporters because they're pre-placed there.
Scott Fauval admits on the hidden camera they hire homeless people to do, quote, crazy shit, and they don't care what the legal and ethics people say, quote, we want to win this motherfucker.
I paid off a few homeless guys to do some crazy stuff, and I've also taken them for dinner, and I've also made sure they had a hotel.
It doesn't matter what the freaking legal and ethics people say. We need to win this motherfucker.
Bob Creamer was fired, the DNC cut the contracts, and Donald Trump mentioned these videos in the debate with Hillary Clinton in Las Vegas in 2016. Now, the undercover journalist Allison Moss had an unpaid internship, didn't sign the NDA, and got inside this group, wore a hidden camera while working for me at Project Veritas in 2016, and now Democracy Partners seeks $1 million in damages against me for, get this, breach of fiduciary duty, and at the time, unlawful interception of oral communications, trespass, fraudulent misrepresentation, and civil conspiracy. It goes to a D.C. jury trial in September of 2022. We litigate all the way to the end, and we lose. We get $120,000 in damages against us. Now, what's interesting in the case is the judge sent the jury back 2 times before they got the right decision. That's a story as well. But here, the issues in this case, we are fighting for the First Amendment itself. The right of a reporter to repeat back what someone tells them. One-party consent recording in Washington, D.C. As my attorney Ben Barr says, if it's fraudulent misrepresentation in this case, then undercover journalism is effectively banned. We'll show some audio from inside the D.C. Circuit Court of Appeals and then go to correspondent Mike Casey, who was on the ground in Washington on Thursday to interview Ben Barr. Now, in the circuit courts, that's one above the federal district court and one below the Supreme Court, we present to a panel of 3 appellate judges. First, Judge Robert L. Wilkins, appointed by Obama, Judge Karen L. Henderson, appointed by George H.W. Bush, and Harry T. Edwards, appointed by Carter. Now we'll take you inside the courthouse there in D.C., where correspondent Mike Casey is standing by.
This is Michael Casey with O'Keefe Media Group reporting outside the D.C. Circuit Court of Appeals, where I just got out of oral arguments in the matter of Democracy Partners versus James O'Keefe, where both sides presented their arguments to a panel of 3 federal judges.
Good morning, Your Honors. My name is Benjamin Barr, and I represent the appellants, James O'Keefe and Allison Moss. I'd like to reserve 3 minutes for rebuttal. No non-disclosure agreement, no salary, no authority, just an unpaid intern clipping newspaper articles, saving videos, taking messages. This is who Allison Moss was inside Democracy Partners, the lowest rung on the ladder. Yet because she recorded what she saw and later shared it with the public, the verdict below reimagines her as 3 things at once: a fraudster, a fiduciary, even a potential criminal. This inversion of reality should give pause to this court. If accepted, the appellee's theory would allow New York Times v. Sullivan to be nullified by creative pleading. Fiduciary law is meant to protect, is meant to restrain those with power, not to conscript the powerless into silence. Fraud is meant to remedy harmful deceit, not to punish truthful exposure. And the First Amendment does not tolerate a regime in which the least powerful person in the room is transformed into the guardian of Washington's political secrets. This court should restore common sense and reaffirm the constitutional principle that journalists may not be punished for truthful reporting simply because the truth was uncomfortable.
Ben Barr also argued that this should have never gone before a jury ever, and he believes they made an impassioned decision that was hasty and rushed. That's why James O'Keefe appealed this, and it's why it's in court now.
My understanding is that there was no objection below to the jury instructions on fraudulent misrepresentation.
That's correct, Your Honor.
And those jury instructions made clear that the verdict wasn't based on publication, it was based on infiltration, right?
Yes, Your Honor.
So what's the First Amendment problem?
First Amendment problem is this should not have gone to a jury at all. As a matter of law, it should have already been decided in favor of the appellants. And this was raised both at motion to dismiss, summary judgment, Rule 50A.
At issue here is the idea that the lawsuit wasn't over defamation. I was not sued for defamation. They're not alleging that what you're seeing isn't true. Everything that you saw in the videos happened. They didn't litigate that. Now at trial, they tried to make hyperbolic arguments about selective editing. They tried to sneak a defamation style case into this case. But this is over the idea that the undercover infiltration itself led to the suspension of the contracts and the damage. But the problem is, it was the publication of the footage that led to all these things happening. For example, if we didn't publish anything, people would not have been fired. If the video didn't get 7 million views on YouTube, I doubt anybody would have cared. If Donald Trump didn't talk about it at the debate, this wouldn't be a lawsuit. So all of this flies in the face of the First Amendment itself. In other words, it's not a fact issue, it's a legal issue. And there's a lot of Supreme Court precedent that we mentioned in this hearing. Hustler v. Falwell, New York Times versus Sullivan.
What we're saying is that the harm that stems from misrepresentation has to arrive directly out of that infiltration or misrepresentation. But where there are publication issues in front, where there's news gathering involved, if the alleged harm stems from the publication, then we have a profound First Amendment issue here.
So what's the First Amendment problem?
First Amendment problem is this should not have gone to a jury at all. As a matter of law, it should have already been decided in favor of the appellant. Cohen says that we look to laws of general applicability in that those don't offend the First Amendment with some special journalistic immunity. And we're not arguing in favor of any sort of journalistic immunity. We're arguing about proximate cause here, and that where there's an intervening publication that causes the damage at issue, that you have to meet New York Times v. Sullivan standard. Otherwise, you're maneuvering around, just as Hustler said, and that can't be done, whether a jury's blessed that or not as a matter of law. That's where we're at. And the publication, the fact that this is a publication damage tracks with clock-like precision the exact timeline here. And it's similar to what happened in Food Line.
Now, Food Line was a case in the 1990s where ABC News, Diane Sawyer, and her outfit was sued for, quote, fraudulent misrepresentation when the reporters went undercover in the grocery store, put hidden cameras in their wigs, and filmed the meat being bleached. Now, that lawsuit was overturned in the Fourth Circuit Court of Appeals in North Carolina, what's interesting about that is that these cases might go to the Supreme Court on the First Amendment rights of an undercover journalist.
And there are lots of cases where folks come away saying, you know, but I don't really like the jury result. And I have a good argument, maybe, but if the jury did what it was supposed to do and they were properly instructed, you lose.
And here the jury didn't do what they were supposed to do. Cohen stands in tension with cases like New York Times v. Sullivan and Hustler. Hustler reminds this court
Cohen
that
takes care of your so-called Hustler argument, and you have no answer for that.
well, the answer is twofold. One, that it shouldn't have gone to the jury as a matter of law.
Yeah, I understand you say that.
Yeah, and this court as a constitutional gatekeeper has its own duty to review the whole record below and to see that the damages were tied to publication, not to the infiltration. Second, that we meet the high standard here, that when we look at this timeline that I just walked through, this lines up perfectly with Food Lion. It lines up perfectly with Desnick. In other sister circuits, finding that where the evidence points towards a finding that the harm comes out of embarrassment from this publication, then we have a Hustler problem, a Food Lion problem, and the like.
What also stood out to me was they argued that she had a fiduciary duty. Fiduciary duty is reserved mostly for major corporate CEOs, the biggest managers of the biggest companies, not for unpaid interns, not for undercover journalists. Journalists have fiduciary duties now to companies? That has never been heard of before, ever. And as Ben Barr pointed out, there's been numerous cases in sister circuit courts that have fiduciary duties for major CEOs, but never for an unpaid intern, never for a journalist. This would be the first of its kind.
We turn to fiduciary duty and the finding of a fiduciary duty owed by Allison Moss to Democracy Partners. That, of course, is the predicate for the wiretapping claims here. Of course, in D.C., it's an open-ended test. That doesn't mean a boundless test. What is the nature of the relationship, the promises made, the types of services or advice given, legitimate expectations of the parties. But immediate problems here are that fiduciary obligations arise only in rare relationships of heightened trust, independence, where one party reposes a special confidence in the other, and the other accepts that, sort of a meeting of the minds. Mouse was a temporary, unpaid intern, not an officer, not an advisor. She wasn't entrusted with managing any sort of affairs. She had no contract, no confidentiality agreement, no decision-making power within the organization.
And you walk out of the room and say, good, I'm going to record everything I hear here and I'll share it as I please. And then I can get away with it because I'll say it's First Amendment protected. Oh, come on.
Well, yes, no, Your Honor, absolutely yes. But that's what investigative journalists do, and that's why major reforms.
They do, but sometimes they may take a chance. That's what this case is raising. Yes. It has to be within the law.
It has to.
But there may be a risk.
We're not arguing any sort of special journalistic immunity.
Right. The Supreme Court has said no, you can't win on that.
No, we can't. Absolutely not. But what we can win on is the fact that this is, again, related to publication damages, and that the finding of a fiduciary standard here is absurd.
Now then, one of the judges pointed out that if this fiduciary standard applies, if there's a fiduciary duty of a reporter in D.C. with one-party consent, she says, quote, there's no more muckraking.
Can I ask you a question that, unless I'm misreading the record, whether this Ms. Moss was a fiduciary or not, and I don't think she was. If she was, then that's the end of muckraking.
I take your point, Your Honor. Yes, it's absolutely important. And to your point, this determination by this court decides whether undercover reporting can exist in the nation's capital moving forward. And we'd ask that you reverse and remand accordingly.
I do have one question.
Oh, yes, Your Honor.
You agree that Creamer is a limited purpose public figure.
Yes, Mr. Creamer's well-known, involved in political circles, is married to a former congresswoman from Chicago. I think that adequately meets New York Times v. Sullivan public figure status test.
Then a man named Mr. Sandler, that's the attorney for Bob Creamer, took over.
Defendants claim in their reply brief, and counsel alluded to it, that if the verdict in this case is allowed to stand, it would, quote, set a dangerous precedent, effectively ending undercover reporting and investigative journalism.
Mr. Sandler, I'm very hard of hearing. Could you either get closer to the microphone or get it closer to you?
Can you hear me now?
That's better.
Okay, thank you, sir. So defendants claim in their reply brief that if the verdict in this case is allowed to stand, it would, quote, set a dangerous precedent, effectively ending undercover reporting and investigative journalism, end quotes. And leaving aside that this verdict has stood for more than 3 years with no noticeable effect on investigative reporting or journalism, that assertion is simply not true. And it's not true because with respect to the fraudulent misrepresentation count, the district court, 2 different judges who presided over this case, indeed kept the First Amendment constraints, the Hustler Doctrine, top of mind, such that, in the words of the district court itself, that court, quotes, only permitted plaintiffs to proceed to trial with claims predicated on harms caused by defendants' non-expressive conduct. In particular, the jury was carefully instructed to that effect, as the counsel's exchange with Judge Wilkins noted, and defendants do not challenge those instructions in this appeal. The expressive conduct, the non-expressive conduct that was found to be a proximate cause of the damages sustained by Mr. Kramer and his company was the infiltration by Ms. Moss of the offices of Democracy Partners. And that included not only access to the private offices in that company, but also inside the headquarters building of the Democratic National Committee and of a major labor union. The access was, evidence showed that the access was all made possible by an elaborate web of falsehoods and misrepresentations, and that in the course of that infiltration, Ms. Moss videoed literally everything she saw and heard all day long without regard to whether the person she was taping was the subject of any journalistic interest, just taping everything to see if anything interesting turned up, including people she didn't even know who they were when she started the day.
And nothing did. Nothing that she recorded or taped or looked at or whatever was the subject of a publication.
That is, yes, that is true. That is true. And that's right. The actual contents of the video, virtually entirely a conversationist with Mr. Fovel recorded in a bar with Mr. Kramer in a hotel lobby and in a restaurant. We didn't challenge any of that because it didn't, that wasn't, had we challenged that, say that was embarrassing, and you selectively edited it, then we would have had to meet the Hustler standard and show and tried it as, pleaded it and tried it as a defamation case. But that wasn't the case here. The jury found that a proximate cause was the infiltration itself. And if the issue is whether a reasonable jury could have found, with all inferences resolved in plaintiff's favor, that a substantial factor in the decision of AFSCME to cancel its contract with Mr. Kramer's company, Strategic Consulting.
What do you think if the video had not come out and that this Miss Moss just had all this collected stuff and she either kept it or gave it to O'Keefe, that this organization that Scott Fry heads up would even know about it, would have any reason to cancel the contract?
It would be speculative whether Mr. Kramer would have mentioned if the video had not come out, they wouldn't even know that the whole thing was the whole internship was a fake.
To your point, Judge Withers, we are asking a lot. I understand this is a unique case. This is about the borderline of protecting First Amendment rights as a constitutional gatekeeper under Bose. And to Judge Henderson's point, Claymore, Hustler both indicate juries get impassioned about these sorts of issues. They decide these issues wrong, and where the First Amendment is implicated, there is a role for this court to be involved, different from almost any other case that would be before this court. I just want to reemphasize that here. The finding of a fiduciary duty here is incredibly difficult and absurd in comparison to what we have shown nationwide and within DC in terms of precedent. There is absolutely no evidence from the record below of direct instructions from Democracy Partners about confidentiality.
OMG correspondent Mike Casey caught up with my lawyer, Ben Barr, outside the courthouse and asked for his take on how it went.
I'm here right outside the D.C. Circuit Court of Appeals with Attorney for James O'Keefe, Ben Barr in this case. Ben, nice to meet you. Can you give us your synopsis of how this oral arguments went today?
Nice to meet you, Mike. Yeah, it was a terrific argument from the D.C. Circuit. This is Democracy Partners v. James O'Keefe and Allison Moss, and it's about testing the boundaries of undercover journalism. When an undercover journalist goes into an operation, do they commit fraud by telling white lies to an organization so they can report on information to the American public? You know, past undercover reporting case law, ABC used to do these sorts of things all the time in the 90s. The case law says for the First Amendment, that's not the sort of fraud that we punish in America. So if you're going out, you're telling these innocent white lies, and you're doing so to produce newsworthy information to the American public, that's protected. And it's especially poignant here in the Capitol. This is where Watergate occurred. This is the home of numerous scandals, and we need that ability to be able to show this to the American public, not to use fake trumped-up torts about owing some high-level duty by an intern to a group. Undercover reporters don't have that. Not fraud, not unless a journalist goes in and commits a serious wrong. I'm all for you hold journalists accountable if they go in and they overstep, and there have been times when that happens. That's not this case. This is a special case about press freedom, even whistleblower freedom within this town. And we don't want to shut down the ability of investigative undercover journalists from doing this in the future. Your precedent will carry ramifications here and throughout the country. Please decide this correctly.
Yes, and you had a good back and forth with Judge Henderson regarding this, how you said this shouldn't have gone to a jury trial at all.
Correct. Well, so the Supreme Court has particular cases, and Hustler v. Falwell is one in particular, dealing with a very incendiary, difficult issue where Hustler magazine portrayed the Reverend Falwell in a very unfriendly light, and Hustler won their case because Falwell claimed, well, that this hurt me so. It was an intentional infliction of emotional distress, and the jury found that to be true. So it's similar to what we heard Judge Edwards say today. Well, the jury already decided this, and I politely reminded Judge Edwards, I don't know how many times that juries often get these things wrong. And Hustler says when we interject First Amendment core issues and we have controversial subjects, in Hustler, a pornography magazine, here an undercover journalism outfit, juries often get it wrong. They get impassioned, and we don't trust core liberties to juries. We say that as a matter of law, an elite judge trained in the law, steeped in constitutional tradition, should interject and say, no, this is off limits. No matter what their opinion is of this, it is protected expression, and we allow that in America.
Another great irony in this whole episode is that Project Veritas fired me, and part of the reason the board did, or one of the many seemingly absurd reasons, is that I spent too much money on litigation, that I should not be litigating this case all the way to the Supreme Court, that I should spend those resources on other things. But it wasn't me that recorded these recordings. It wasn't me that was out there in the field. That would have been Christian Hartsock. And one of the great ironies is that, we find ourselves taking bullets for those people personally, even right now, raising hundreds of thousands of dollars to make sure that we're indemnifying their reporting, because we're the face, or I'm the face of the organization, and therefore I take on that responsibility and that liability. But you kind of have to stand in awe of the irony of them wanting to be the face without wanting that accompanying responsibility. That's a story for another day.